Ladies and gentlemen, welcome to the National Constitution Center. It is such an honor for the National Constitution Center and the Federal Judicial Center to convene judges from across America to come to Philly to celebrate the Super Bowl win. I think I saw a slight dissent there from the Eighth Circuit, but it's very meaningful to reconvene this great collaboration between the NCC and the FJC. We had to take a pause because of COVID. We're now back in business, and this is one of the most illuminating continuing judicial education programs in the country. It's a great honor to convene judges of different perspectives to come to Philadelphia on Independence Mall, across from Independence Hall, to reflect about the core values of the Declaration and the Constitution, and to bring together great American historians and legal scholars of different perspectives to explore core questions at the center of the Constitution. Today, we take up one of the most towering and significant of those questions, and that's the constitutional legacy of Reconstruction. It's so great to do it here at the NCC. We are here with a legacy of Reconstruction exhibit, and after the program, we're going to go see Dred Scott's Freedom Petition and Frederick Douglass's Inkwell and rare copies of the Reconstruction amendments. And then I want you all, both those in the audience and those who are watching online, to go online to the Interactive Constitution and look at the drafts of the Reconstruction amendments. Kurt Lash digitized all of the early drafts so that we could put them online, and you can see how an early draft of the 14th Amendment would have protected voting rights. But that draft fell off because there wasn't enough support in Congress. You can see how the language changed from Congress shall have the power to protect to no state shall abridge. And by tracing the evolution of the text, have a sense of the deep contestation about every aspect of the amendment that is reflected in the final amendments. It's that contestation that we're here to discuss today. We have two really significant panels on the historical origins of the 14th Amendment and its meaning before and after it was passed. And we couldn't have better historians to discuss it. So let me introduce them and we'll get right in. And for this, I need my constitutional reading glasses, and here we go. And I'm going to do this very briefly because they're well known, and here they are. Pam Brandwein is professor of political science in the College of Literature at the University of Michigan and professor of law by courtesy at Michigan Law School. She's the author of Reconstructing Reconstruction, the Supreme Court and the Production of Historical Truth, and Rethinking the Judicial Settlement of Reconstruction. Ilan Wurman is Julius E. Davis Professor of Law at the University of Minnesota. He's the author of A Debt Against the Living, An Introduction to Originalism, and Second Founding, An Introduction to the 14th Amendment. And Sherrilyn Ifill is Vernon E. Jordan Esquire Endowed Chair in Civil Rights at Howard Law School, where she has just launched the 14th Amendment Center for Law and Democracy. She previously served as former president of the NAACP Legal Defense Fund and is author and working on a forthcoming book, Is This America? Pam Brandwein, let's jump right in. Your book, Reconstructing Reconstruction, the Supreme Court and the Production of Historical Truth, really is one of the most important and illuminating introductions to the deep areas of contestation that surrounded so many of the final clauses that ended up in the 14th Amendment. Why don't you start us off by telling what the context was, why was it passed, and what were some of the big areas of debate about its meaning?
Sure, and it's wonderful to be here. And I guess the easiest way to start is to be clear about the differences among the Union coalition. And so understanding that, first of all, the anti-slavery coalition, the coalition that formed for free soil as a policy, was made up of just a wide variety of factions. And among those factions were everybody from black activists who had agitated for equal property contract suing rights to white supremacists who wanted the Western territories for free white labor. And so there was an agreement among the Republican faction that slavery should be contained. It should not extend into the Western territories, and with the idea that you're eventually going to suffocate it. But the objective was contested. Is the rest of the country for freedom? Is it for black equality? Or is it really for white labor? And so there's that faction, or there's that coalition. And then understanding the Union coalition is also vital, because once South Carolina fired on Fort Sumter, you have a group called the War Democrats. These are the popular sovereignty Democrats. They wanted Western territories to decide the slavery question for themselves. And once South Carolina fired on Fort Sumter, these folks who believed in white popular sovereignty, this is Stephen Douglas, this is Andrew Johnson, these War Democrats then joined the Union coalition. And so once we get to Reconstruction, there's a very broad group in Congress that all supported the war because the Southern states had seceded. So everybody left in Congress supported the Union effort, but it ranged from more radical Republicans to these War Democrats. And so the agreement to fight the war just breaks down. And you have multiple lines of contestation. And one of those lines was between Republicans and the old War Democrats who believed in white popular sovereignty. And they said, okay, well, the war is over. We now have formal emancipation, and the South is going to renounce their war debt, and they're going to say, okay, no more secession. But they believed in the black codes in the South because that's still white popular sovereignty, and you have formal emancipation. So for the War Democrats, the issues of the war are over with the 13th Amendment. For the Republicans, and again, there are going to be divisions among Republicans, they said emancipation means much, much more than formal emancipation. And so you have these new arguments over what emancipation means, over what the 13th Amendment means. And those arguments unfold actually after the passage of the 13th Amendment. And so it's in debates over the Civil Rights Act of 1866 and then the debates over the 14th Amendment that you have the Northern Democrats, the old War Democrats. Folks can be fighting for the Union and against all Reconstruction policy. Those are the War Democrats. And then you have the Republicans who disagree among themselves over, well, what is the meaning of civil rights? What is the meaning of freedom? And so you have arguments among Republicans over, well, is it civil rights, property contract suing, testifying, equal criminal penalties? This is in 1866. Then you have more radical Republicans who will say, well, freedom means more than that. It means more than equality in those rights. It means equal suffrage in 1866. And those arguments by radicals were rejected by centrists immediately. But with deep, deep, deep resistance to even the most basic equal civil rights in the South, centrists move, they expand their definition of freedom. And so yes, there's an argument over what freedom means, and that gets incorporated into arguments over what the 14th Amendment is for, because Republicans came to understand very quickly that the 13th Amendment wasn't going to be enough, that it was already being litigated in mid-Atlantic states. New York had a case over the 13th Amendment involving landlords and tenants where you have case law early that says, well, all the 13th Amendment does is give formal emancipation. And that's it. You had a case in Delaware that said, well, we're going to get rid of the Civil Rights Act of 1866 because we don't believe that black folks have a right to testify against white folks. And so the 13th Amendment became unreliable in Republican minds as constitutional law very early on. Even the Civil Rights Act of 1866, which was originally passed to enforce the 13th Amendment, the authority of that even becomes undermined by the courts. There are Republicans, all Republicans wanted to overturn the Dred Scott decision. They wanted to establish citizenship. Folks came to realize that, oh, the 13th Amendment really isn't a guarantee for Black citizenship in the North. And so you need a citizenship clause beyond the citizenship clause in the Act of 1866. And so the arguments among the Union coalition, Northern Democrats versus Republicans, and then among Republicans, give us the 14th Amendment, but that really just extends the argument. It opens up, it continues arguments over what is the meaning of equality, what is the meaning of freedom. And in a context where the Ku Klux Klan is mobilizing with tremendous effect, you have arguments over what does it mean for a state to guarantee the equal protection of the law, when in all of these southern jurisdictions, civil authorities cannot be counted on to enforce the law. And so when states and local authorities are doing nothing, does that count as a deprivation of rights? And there's a consensus among Republicans that it does, that the unequal enforcement of the law when it comes to political violence and racial violence counts as a violation of equal protection. And these things unfold as arguments over the 14th Amendment are being debated. So I will stop there for now.
That's so helpful because you set up a series of important disagreements which help us understand the terms of debate. First, you said that there was a disagreement about whether you just needed to end slavery or whether you also could pass the Civil Rights Act to guarantee civil equality, and then that disagreement among Republicans about what was civil equality. Was it just civil rights in the Civil Rights Act, or did it include political or social rights? And then that question of how to enforce it. Do you need a state to refuse to act, or could the federal government act proactively to prevent private deprivations? Ilan, in your important and clear and really marvelous book, you make a textualist argument for the meaning of the 14th Amendment based on its original public meaning, although not its legislative history. And tell us about the relationship between the Civil Rights Act of 1866, which gave all people the right to make and enforce contracts, to sue and be sued, and to engage in private rights. And you can do the whole amendment if you think you can do it quickly, but focus on the Privileges or Immunities Clause for this round, because that's going to be the source of much of our conversation.
So first, I just want to correct one small part of the record. How do you unburnish one's credentials? So that's what I'm not a historian, but I rely on wonderful people in this room. And what I'm trying to do as a legal scholar is figure out, in light of all this historical scholarship on the objectives of the 14th Amendment, what language did they use? And my view is that I think the 14th Amendment, and actually much of the rest of the Constitution, is written in what scholars have called the language of the law. They have these terms, privileges and immunities of citizenship, protection of the laws, due process of laws, have these long antebellum, I say antebellum, I mean going back to Magna Carta, legal meanings. And these legal meanings, I argue in the book, were successfully deployed to solve the problems that were confronting the framers in the 39th Congress. So one of these problems was, the citizenship rights, not only diversity jurisdiction, for example, in the Dred Scott case, but are free Black citizens of northern states entitled to the privileges and immunities of white citizens in other states? There's a clause in the Constitution, Article 4, that seems to say they are. And so this was one of the problems they were confronting. There was the equality within a state, right? So that's the interstate equality, Article 4. Then there's equality within a state, not just the Black codes in the South, but in the next panel, Kate Macer has a wonderful book explaining that this had been going on in the North too. And there was these pushes for equality among a state's own citizens as well. And then even if you establish equality, it doesn't do you much good if the Ku Klux Klan can interfere with your rights, right? It's one thing to guarantee due process against government depriving you of rights. But the government isn't the only one who can deprive you of rights or annoy you or interfere you in your enjoyment of rights. I mean, we all have neighbors, right? Private parties can interfere with your use and enjoyment of rights too. And that is what I think the Equal Protection Clause does. And so what I try to argue in the book, and I guess I've convinced one person, which is great.
Well, I didn't say convinced. I said it was marvelous and illuminating. Absolutely.
Is that these legal terms solve for these problems, or at least they thought they were solving the problems, and they would have solved it if various actors hadn't abandoned it, and the Supreme Court hadn't abandoned the language and the promise in various cases. As for so to answer your question directly, you can set up those three sort of problems. It doesn't necessarily answer how they thought they were solving them. So a lot of people think that the Privileges or Immunities Clause was intended to incorporate the Bill of Rights against the states, that this is how you guarantee equality, just nationalize rights, nationalize the first 8 amendments. No state can violate the first 8 amendments or the other fundamental rights of citizenship, and now everybody's equal in that sense. But that raises interesting questions. Can you, above the fundamental floor of privileges and immunities, are you allowed to discriminate in the provision of those kinds of rights? Anyway, the claim that I try to make is that the Privileges or Immunities Clause actually was not intended to incorporate the Bill of Rights against the states. It was presumed that all the state governments guaranteed these fundamental rights to their white citizens, because all free governments had to, and the objective was to just ensure that they don't arbitrarily discriminate in those rights against black citizens or citizens of any color. And so a lot of people, and so there's no question that the 14th Amendment was intended to give a constitutional basis to the Civil Rights Act of 1866. As Pam just said, some people, the Republicans, thought that the 13th Amendment empowered them, but that was an open question whether the 13th Amendment empowered them to interfere in the civil rights legislation. And even if it did, what happens when the Democrats take over, as they did in 1875? What's to stop them from repealing the civil rights legislation? So James Garfield, who was then a representative, said, it's actually a wonderful, James Garfield has some of the most wonderful lines in the debates. When they were pushing for the 14th Amendment, they were accused of the Civil Rights Act that they had enacted was they thought it was constitutional. They had said it was constitutional, so why do you need the 14th Amendment? So they were accused of being sort of duplicitous. Aha, you're admitting that the Civil Rights Act was unconstitutional. You're admitting you all violated your oaths. And what did James Garfield said? He's like, no, we need the 14th Amendment to guard against the sorry day when the Gentleman's Party will take over this house and repeal the civil rights legislation. And so there's no question that they had to figure out a basis for the Civil Rights Act. And what I try to show is if you use the legal, historical language of what protection of law was, which was protection against private violence, against Ku Klux Klan violence is an example. Due process of law, protection against government deprivations of existing rights. The only clause that does the work of getting us the Civil Rights Act of 1866 is the Privileges or Immunities Clause. And so what I argue is that really it's just an equality provision. States can regulate and vary the rights that they offer. They just can't arbitrarily discriminate. Now, how do you know it's an arbitrary discrimination? That's a whole problem. But the upshot is, I think most people are wrong about incorporation as a historical matter, maybe not as a normative matter. I think under my view, it means California can ban handguns, right? It just can't say only white citizens are allowed to have guns. I think it means California can pass a law that says you require a license to operate a laundromat in a wood building. What it can't do is deny every Chinese applicant a license and grant all the white applicants a license, right? So they're allowed to regulate the rights, but they can't arbitrarily discriminate in the provision. At least that's the claim that I try to make, and I went over too long as it is.
No, that's great, and look forward to digging into all those questions. Sherrilyn, you have argued for what you call a radically transformative argument of the vision of the 14th Amendment, because that's what many of its proponents sought, and you've invoked the anti-caste principle that Charles Sumner and others invoked as a core of an amendment that didn't just constitutionalize the Civil Rights Act, as Ilan says, but guarantees the full equality before the law to all individuals. Tell us more about your vision of the 14th Amendment and why you think it's rooted in its history.
Thanks so much, Jeff. Thrilled to be here always at the National Constitution Center. I think it's important to give a little bit of political dynamic to this because, we should remember what was happening in this period when the 14th Amendment was being conceived and drafted. We had just gotten through the Civil War, 600,000 people dead, and in fact, the Civil War was still going on in places around the South. In Texas, there were still skirmishes. In what is now Oklahoma, there were still skirmishes. So it wasn't all settled. This was a very unstable time. We have Lee's surrender at Appomattox, and 6 days later, the one man who was believed to be the man who could hold the Union together, the president, is assassinated. That is the context in which Congress is coming forward to try to figure out how to stitch together this country. The new president, Andrew Johnson, who had been Lincoln's vice president, is, as Pam said, one of those who was a Union man, but was not necessarily an anti-slavery man, and was certainly a very explicit racist, and certainly believed in the inferiority of Black people. And so part of the struggle that develops is Johnson's idea of Reconstruction and Congress's idea of Reconstruction. Johnson's idea of Reconstruction is let bygones be bygones, bring all the southern states back in, the war is over, and let us proceed as a nation. But you have members of Congress who are deeply concerned about that scenario. How do we know that the people that we're bringing back in who will be representing their states are in fact loyal to the Union? How can we simply allow people who participated and even led insurrection to come forth and be part of the government without some measure of understanding their loyalty to our country? And so they have a different idea of Reconstruction, and they also have an idea of what will be necessary to make the 13th Amendment true. Now, yes, we did have the Civil Rights Act of 1866, and this is where Johnson comes in. Congress passes the Civil Rights Act of 1866, and President Johnson vetoes it. Now, Congress is able to override that veto, but it becomes now apparent that a president or even a new Congress might overturn the Civil Rights Act of 1866. And that is largely the impetus for deciding that these rights have to be enshrined within a constitutional amendment so that they cannot be moved. The other thing that I think is important is that this is such a dynamic period. The people who are working on this project of the 14th Amendment are learning as they go. President Johnson, who, as I said, believed that we should let bygones be bygones, seeks to shore up his position by sending a good friend of his, an emissary, Karl Schurz, who was a German national, to go down south and investigate what the conditions are in the South, in the belief that Schurz will come back with a report that says, the South is ready to rejoin the Union, let's move on with this. Meanwhile, the Joint Committee on Reconstruction is doing their own investigation of conditions in the South as well. So these are not just men sitting in a room writing. There is some research that is done that becomes the platform for thinking about what is necessary. And Karl Schurz, who's the great buddy of Andrew Johnson, comes back with a report that's not the report that Johnson was expecting. He comes back with a report in which he is surprised and dismayed by the level of insurrectionist spirit that he says remains throughout the South. He's dismayed by the level of white supremacist ideology that exists in the South. He is able to give account of Black codes that are beginning at that time, and so the use of law enforcement to return Black people to something like slavery. He talks explicitly about the belief that seems stubborn among Southern whites that the only way Black people will work is by being whipped. And he expresses deep concern about educational opportunities for Black people when recalcitrant Southerners are in control of the educational system. And that's the report that he comes back with to Andrew Johnson. The Joint Committee is also concerned. As a matter of fact, the Joint Committee is deeply concerned because they have experienced former Confederate generals and even the Vice President of the Confederacy, Alexander Stephens, who arrived at the United States Congress saying, we are here, we want our seats, we represent our states, I've been elected by the people of Georgia, let's go. And they barred them from entering. So they're having their own experience with this effort to try and return to power without any demonstration of loyalty. And in the Schurz report, what he says that's very alarming is he says in his account, most whites in the South, there are some who have said, we lost the war, let's just get on with it so we can get back to making money and living our lives. But he says most actually just want to get back to power. They actually don't believe they did anything wrong. They actually have no loyalty to the Union. They actually don't think that Black people should be free and certainly never equal. But what they want to do is yada, 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 get on with whatever stuff you're doing so that we can get back to power. And so it's important to know that all of that material is influencing those framers who go into the room, who now, after the veto and overcoming the veto of the Civil Rights Act of 1866, realizes that this is something that could change and needs to be enshrined in a constitutional amendment. And it is those reports that influences the 14th Amendment. We get Section 3 on insurrectionists returning to government out of that experience of the Joint Committee. We get Section 2, which creates a punishment regime for Southern states that will not allow Black men to vote. Out of what they learn is none of them believe that Southern states will allow Black men to vote. And I say men because at that time women could not vote. So they're very much informed by this, what they are seeing on the ground. And I think this is important because when we're interpreting the 14th Amendment, there is that language that is sometimes impenetrable. But it's critical to understand the context in which they were making decisions about the language, making decisions about what to include, what are the things they argued about and didn't argue about. Yes, indeed, they did understand that Dred Scott had to be overturned. And that forms the first sentence on birthright citizenship, which I know you all are going to talk about later. But when you do talk about it, note the positioning of power, because the 14th Amendment is really a reordering of power, of the power dynamic between the federal and the state government. The first Constitution and the Bill of Rights is all concerned with protecting us against the excesses of the federal government. And what the Civil War teaches us is that we also need protection against the excesses of state governments. And so the opening line of the 14th Amendment is every person born in the United States, born or naturalized in the United States and subject to the jurisdiction thereof, is a citizen of the United States and of the state wherein they reside. Your state citizenship flows from your national citizenship. And you know this, in the early 1800s, you were a Virginian, you were from Pennsylvania, you were a New Yorker. Your national citizenship wasn't really that important. But the 14th Amendment changes that, and note that reordering, the repetition of the words "no state shall." This is fundamentally an effort to enshrine in the federal government the power to protect that which these framers believed and knew Southern states would not protect on behalf of Black people. And so understanding that context to me feels essential to trying to figure out what privileges and immunities means, figuring out what birthright citizenship means, figuring out what equal protection means. Why do you need equal protection if privileges and immunities encompasses equal protection, right? So there's a lot there. But this is an amendment, Eric Foner, who I think is going to be with you tomorrow, calls the 14th Amendment, and I agree with him, the most consequential provision of the Constitution after the Bill of Rights. And, yet outside of this room, because I know you all are esteemed and learned, as you know, most people on the streets would not be able to tell you a framer of the 14th Amendment. They could tell you about the first Constitution, they could tell you about Hamilton, they could tell you about Jefferson, they could tell you about Washington, but they wouldn't know Bingham, they wouldn't know Stevens, they wouldn't know Sumner, they wouldn't know Frederick Douglass, because Kate and others will talk about this. There were lots of influences on the 14th Amendment in the many years before it. So I think understanding that context is really critical to, you can't just walk up to the 14th Amendment and think you can just read the words, at least in my view. This was created in the crucible of national crisis. And the people who created, drafted, and ratified the 14th Amendment had to have a powerful vision of this country that had never been, which is what I find most exciting about it. They were creating a country that had never existed. And in that way, they're very much like the civil rights activists who also tried to give the 14th Amendment meeting, who were also creating a world that they had never seen. They had all been raised in essentially legal apartheid in the South, and they had a vision that it could be different. Well, that's who these radical Republicans were. They also were creating an America that had never existed. We'd never had an America where Black people were free and equal citizens, where they were counted as whole persons for purposes of representation, where they were entitled to equal protection of laws. So without understanding that dynamic context, I think we're doing a disservice to the power of what I consider to be really one of the most consequential measures of the Constitution.
So powerful, you present it so compellingly, and calling out those framers, Bingham, Stevens, Sumner, Frederick Douglass, as well as Carl Schurz, who wrote that report that galvanized the framers and the unsung heroes of the civil rights movement, both in the antebellum period and afterward, all the way up to today, is just crucial in teaching the history, and that's why all of the historians who we'll be talking to today have performed such important service in telling those stories.
I'm also not a historian.
You are indeed, and you're a legal scholar.
I've been anointed.
We did the best panel over the summer at the Aspen Institute, where we told the story of the 14th Amendment. The assignment was in 20 minutes, and just by telling the stories, it just brings it to life, and I think you want to do a podcast series.
I do. We are going to. You don't know that, but we're going to work on that.
It's going to be great. Well, teaching history through storytelling is crucial, and that's just what we're going to do today. Pam, let us focus on the debate over the Civil Rights Act of 1875. You tell the story, Charles Sumner, on his deathbed, my bill, don't let them forget my bill, expires. And then the bill, which he had proposed originally to cover a range of public services, including the right to go to schools in a non-discriminatory manner, is whittled down so that it forbids discrimination in public accommodations, theaters, public transport. And that passes, and then the Supreme Court strikes it down in the civil rights cases by Justice Bradley, who seems to be the Zelig of Reconstruction and is just there to strike down central pillars of Reconstruction at every moment, starting with the Ku Klux Klan Act of 1871 to the Civil Rights Act of 1875. Pam, you really tell that as a story between different visions of Reconstruction, between centrists and moderate Republicans who have different visions of Congress's power to forbid forms of private discrimination, as well as a different understanding of what the distinction between civil, political, and social rights is. So tell us about the debates over that amendment and what it can teach us about what the 14th Amendment means.
Sure. I actually wanted to start by underscoring something that Sherrilyn had said in terms of the envisioning of a new country, because the centrists, before I say something about the limits of their egalitarianism, because there were limits to their egalitarianism in Congress, the things that bound them to the radicals, and Reconstruction legislation was really centrist legislation. The centrists moved to embrace a number of the policy positions that the radicals, where they were in the avant-garde, especially in terms of voting. But the centrist Republicans had deep, deep, deep commitments to re-envisioning this country. And it was the centrist, it was Richard Henry Dana who originated what was called grasp of war constitutionalism. And this was the theory by which the centrists, along with the radicals, authorized their reinterpretation of the United States as a biracial polity. And it was this idea that the South was still prosecuting the war. The war didn't end with Appomattox in the minds of the centrists, because they were still prosecuting the war in the South. And this grasp of war constitutionalism is what authorized for the centrists the Reconstruction Act of 1867. And this happened after the South, all the ex-Confederate states except Tennessee refused to pass the 14th Amendment. They said, no dice, we're not passing it. And Congress was like, okay, we've gone through all of this. This amendment must pass before you guys can come back into the Union. And this Act of 1867 authorized the military was going to go back into the South. They were going to reconstruct Southern governments. Black suffrage was provided by statute. And it was that measure that enfranchised black men in the South, and you got these Reconstruction governments, and it was these governments that passed the 14th Amendment. So there were really two 14th Amendments, the one that Congress debated in 1866 that was not passed, and then the one that finally got passed after the Reconstruction Act of 1867. And the reason I wanted to emphasize this before turning to the limits of centrist republicanism is that the centrists really there was complete consensus on Black equality and civil rights, property contracts, suing, equal criminal penalties, equal punishment. If you were attacked because of your race or your contract rights were infringed because of your race, the centrists believed that that was a violation of equal protection if local authorities did not provide a remedy. And this was sort of the core basis on which centrists and radicals agreed. And they came to embrace the right to vote on top of that. Now, when it came to public accommodation rights, the right to be buried in a cemetery where there were white and Black people, the right to travel on integrated ladies' cars, the centrists in Congress tended to reach their limit. The radical Republicans had been pressing for equal public accommodation rights, and this was where the centrists this is kind of the third rail for them, because their egalitarianism ran up against the idea of white purity becoming at risk. And there are beliefs, even among Judge Hugh Bond. Judge Hugh Bond was one of the very strong Reconstruction judges. Even Hugh Bond, who would put Klansmen in jail, said, I believe just because I believe in Black equality, and I do believe in Black equality, that doesn't mean I should eat or sleep with a Black man. And this is coming from a judge who is Reconstruction down the line. And so one of the things to understand about centrist Republicans is they're very mixed racial ideology. They're committed to egalitarianism, but only up to a point. And so this notion that racism is a dichotomy is something that needs to be put aside to understand centrist Republicans. Because when we think of racism as a dichotomy, we've got Frederick Douglass and we've got the Klan, but you're not really actually able to understand the centrist Republicans. And when it came to the Public Accommodations Act, the centrist Republicans, they bottled up Sumner's bill for 5 years. They weren't going to let it get to the floor. And centrist Republicans, Matthew Carpenter, senator, strong supporter of Reconstruction, supported Myra Bradwell in women's suffrage. Carpenter got the bill sort of out clean with just the public accommodations provisions, not the school provisions, which were really the most incendiary. And even when it was just the public accommodations provisions, the bill wouldn't pass. And it really passes because Sumner died. It was passed as a memorial to Sumner, and even Republicans didn't put a state action requirement into it. So all of the other legislation had state action requirements in it, which were understood to also include the notion of state neglect. But they put the public accommodations bill out there without a state action requirement, knowing that the courts were probably going to strike it down because it lacked a state action requirement, and that it was really understood as a memorial to Sumner. And when it gets to the Supreme Court, you have a decision that I think is actually mostly misunderstood, because folks don't understand that there's a vocabulary of rights that is being used at the time to distinguish between civil rights, again, civil rights at the time, not our definition of civil rights, much more narrow, property contract suing, testifying, equal criminal penalties. And then this category called social rights, which was sort of invented. It doesn't have a legal history in the same way that civil rights has a legal history. And then the category of social rights was sort of invented once emancipation came online as a sort of a possibility to preserve an area of caste, to preserve that area of society where white folks maintained a white superiority over Black folks. And again, that's where centrists reached their limit. But this vocabulary, civil, political, social, was used by the court in the civil rights cases. And so in the civil rights cases, which struck down this act, which centrist Republicans had predicted back in 1875, Justice Bradley points to the Civil Rights Act of 1866 as valid, paradigmatic corrective legislation. And he says this is what corrective legislation looks like. When you have a state neglect requirement, property contract suing, testifying, civil rights are valid, but public accommodation rights are social rights. And centrist Republicans had actually never really been committed on principle to social rights, committed to civil and political, but not social. And so that act gets struck down. And one of the things I think is unfortunate about the historiography of Reconstruction is that that distinction between civil and social has not been preserved. And so in addition to this notion of state neglect, which I actually think is articulated by Justice Bradley in this opinion, the civil rights cases has been read as this wholesale rejection of civil rights, when it actually is not. It's a rejection of what were called social rights, and this understanding of what counts as a state denial of rights has also been read through a 20th century lens, and that when you understand the vocabulary of state neglect that was developed in multiple sites at the time, newspapers, Congress, state-level conventions, Bradley actually uses that language when he's talking about the deprivation of civil rights, in addition to political rights. So this social rights notion is carved out. And again, it's the limits of centrist Republican egalitarianism. And so understanding the vocabularies by which freedom was debated, and in which centrist Republicans moved to embrace a larger and larger understanding of Black equality. This was their limit. It was tied up with notions of white purity, which they subscribed to, even though they were committed to these other rights.
It's such an important reminder that the central questions over the Civil Rights Act were essentially contested. Could Congress ban discrimination without state action or not? Sumner said yes, the moderates said no, and the court sided with the moderates. Was public accommodation a civil right or not? Bradley said no. Justice Harlan said yes, because trains and steamships were common carriers, and it was a quasi-public accommodation. Your scholarship suggests there was no single original public meaning of this text, but really essential disagreement on these central questions. Ilan, you said some people disagree with your vision of Reconstruction and the Privileges or Immunities Clause, and among them, of course, was the guy who wrote the 14th Amendment, John Bingham, who Sherrilyn called out. And Bingham actually stands up in Congress and said, I'm writing this to incorporate the Bill of Rights because I read Chief Justice Marshall and Barron in Baltimore. And Marshall said, if you want to incorporate, use the words no state shall. And Bingham says, imitating the Chief Justice and imitating him to the letter, I put those words in the Constitution because I wanted to incorporate the amendment. But you argue in your illuminating and powerful, but not necessarily entirely convincing book, that original understanding doesn't matter. And you also argue that the original understanding doesn't matter on the question of whether schools segregation is unconstitutional and whether Brown is right. Because although it's true that some people stood up in Congress and said, don't worry, schools aren't going to be covered, and while it's true that schools were removed from the Civil Rights Bill because people didn't think they were a civil right, you say it doesn't matter what people thought then. If schools are a civil right in 1954, then Brown is okay. So broadly, I guess, I want you to say more about why your approach, which really is textualism, not originalism, is persuasive, given the fact that these questions that Pam has just been flagging, are schools a civil right or not? Does Congress have the power to ban private discrimination or not? Are essentially contested. There's no single public meaning in the text, and the original understanding is often on the other side. So why should we accept your interpretation?
Yeah, okay, wow. So I'm looking at the time, which is here. There are two things I will try to address. I'm going to start with the John Bingham point. It is true that in 1871, he came up and he distinguished the rights of state citizenship from the rights of federal citizenship in the Bill of Rights. And he said, my intent was those were covered by the privileges or immunities of citizens of the United States. That was in 1871, though, 5 years after he drafted it. I'll get to the 1866 speech in a moment. And I already flagged for you that James Garfield has some of the most wonderful lines in the historical record. In that same debate, he responded to Bingham on a related point, and he said, the gentleman may make history, but he cannot unmake it. I was there in 1866. This is not what you said in 1866. This is not what the discussion was. Even Jacob Howard, who is believed to have this incorporation speech, said the entire point was to get rid of the class legislation in the South. It was not anything about incorporating or making applicable the Bill of Rights. So when John Bingham in 1866 said the Civil Rights Act was unconstitutional because of a want of congressional power to enforce the Bill of Rights against the states, what can he possibly mean? What did the Civil Rights Act of 1866 have to do with the Bill of Rights? Contract, property, now there were some due process rights in there, of course, to sue in courts. There was some protection of law and so on. But for the most part, the subject matter of the Civil Rights Act of 1866 is not overlapping with the subject matter of the first 8 amendments. So what did he mean when he said we need a power to enforce the Bill of Rights in order to get the Civil Rights Act, which required equality in contract and property and so on? Well, it all goes back to his understanding of Article 4 of the Constitution, the Privileges and Immunities Clause, guaranteeing the citizens of each state the right to all privileges and immunities of citizens in the several states. He had a reading of it. This is an anti-slavery reading of that clause, which required the states not only to treat interstate travelers from other states equally with their own citizens, but to treat their own citizens equally, the state's own citizens equally. This is what they thought made various black codes in the northern states unconstitutional. And so when he says to enforce the Bill of Rights, he also tells us what he thought the Bill of Rights included. He actually says these provisions of the Bill of Rights. And then he says due process of law and Article 4, the Privileges and Immunities Clause. He defined as being within the Bill of Rights. The Bill of Rights as the first 8 amendments, sometimes it was referred to as the first 8 amendments, but it had much broader and varying definitions at the time. So how do you get the Civil Rights Act of 1866? Well, he said these provisions of the Bill of Rights, including Article 4, and he had a view of Article 4 that required states to treat their own citizens equally. That's how you get it. And all of his statements in 1866 are consistent with that until 1871, where he did change his tune. And then I just will invoke Garfield's sort of response to that. Look, and I may be wrong, and obviously there's a range of plausible original meanings. I don't deny any of that, right? What I'm trying to get at is what seems to me to be the best historical understanding. And there are other historical understandings, and who's right? Well, depends on how many people we convince, I suppose, right, to agree with us. There's no, you can falsify certain things, but can you say this is the best reading of multiple plausible meanings? It's very hard to falsify or to prove. Really quick on the Brown v. Board, I just wanted to, again, echo, they totally made up the concept of social rights. This is absolutely true. I have a paper that tried to go through, antebellum uses of the word social rights. It was identical to civil rights. They just defined social rights to be civil rights until they got to the late 1860s when they had to implement the Privileges or Immunities Clause of the 14th Amendment, and they tried to claw back. The Democrats tried to claw back on it. And so they said, well, when the Republicans said, well, we don't mean that this requires social equality, the Republicans, I don't think they were saying anything new there, actually. What they meant is, if you strike down the anti-miscegenation laws, it doesn't mean you have to marry, you have to associate with someone of the other race. But the Republicans never denied that public accommodations were a civil right. They never denied it. None of the Republicans did. Because, as you said,
the centrists did.
Some of the centrists did? Well, James Wilson, he has this ambiguous phrase where he says, well, it doesn't mean you'll have to go to the same schools and things like that. But it's not clear that he meant that schooling was not included in the Civil Rights Act, right? And so it just seems to me, where was I going with this?
I'm sorry.
No, it's okay. I wanted to be responsive to the point. But anyway, so what they were trying to say is that public accommodations, there's these wonderful lines that says, it is a civil right when you take a train, right? You must associate with the, to take a songs, the gypsies, the tramps, and the thieves, right? Along with everybody else. Everyone, that's not association. Everybody has the same right to access public accommodations. They understood that as a civil right. Was public education a civil right? Except with maybe James Wilson, Henry, which Wilson was it? All the Republicans said, public education, if financed through a scheme of general taxation, was a civil right, and therefore a privilege and immunity of citizenship, as far as I know. And the record might reflect differently, there might be disagreements. So that's what I would say.
Thank you so much for that. Sherrilyn, as I listen to this really great and deep historical conversation, I am struck by how much turns on contested meanings of the same text. Ilan said we've got to pick the best meaning. You have argued that the best meaning includes putting a central emphasis on anti-caste legislation. And people stood up in the debates over the amendment and said this is meant to end the idea of a caste system and laws that imply inferiority or subordination. What's the consequences of that for your vision of the interpretation of the 14th Amendment today, and why do you think that's a better interpretation than others that focus more, for example, on colorblindness?
Yeah, I just think it's important to, well, we should talk about colorblindness in a minute, but I think it's important
I
think it's important to try to figure out what was the goal. What were we trying to accomplish with the 14th Amendment? And, in 1868, there wasn't even really a public education system in the South. Public education is a result of Reconstruction, as a result in the South, I mean. In the North, there were some schools, and very few could go to them, but there were schools in the North. The South did not have a system of public education until the Freedmen's Bureau began to create schools. That's really where it began. So thinking about whether schools would have been conceived of as part of the rights associated with the Civil Rights Act of 1866 or even the 14th Amendment at that time is a bit of a strain, because this is not how the role that education played and public education played in the South, which was the focus of the amendments. And that's why Chief Justice Warren says in Brown, whatever was the situation in the 19th century, today education is the very foundation of citizenship, and it is hard to imagine any child becoming successful without the opportunity to be educated, right? When I ask students in my seminar, what do you think are the privileges and immunities of citizenship? And to a fault, every one of them says, well, first, the right to vote. And I say, well, it's actually not. But that's what they think.
It was not covered.
And who's to say it's not, right? Because today, it's very hard for anyone to think of the concept of being a citizen without being able to vote. That was easy to imagine in 1868 because women were citizens and couldn't vote. So there actually was a template for it. But today, I think we see those things as being coterminous. And so I guess what I'm suggesting is it makes more sense to me to go to the goal. And if the goal was to remove caste, if the goal was to ensure that we were not creating classes of citizens, this is where the public accommodations piece comes in for me, because if the purpose of separating, back to Justice Warren again, is to imply the subordination of one of the groups that you're separating, then it serves the maintenance of a caste system. And therefore, it is what the 14th Amendment was meant to get at. And that's what Earl Warren says in Brown, which is he recognizes that the purpose of segregated schools is not, because they're not separate and equal, and they never could be. So the purpose of it is to suggest the inferiority of one group. And once you do that, you are violating the spirit and the intention of both the 13th and the 14th Amendment, to be perfectly honest. So I think that's why I'm constantly saying to just read the words, especially in this dynamic period, doesn't help us, it doesn't tell the whole story of how we should be looking at what these provisions mean. The other thing I wanted to say is I talked earlier about the framers learning in real time. And this is why the Ku Klux Klan hearings of 1870 and 1871, which very few people even know happened, are so important. So here Congress, because of the proliferation of mob violence, and President Grant is quite concerned about it as well, holds a series of hearings. They hold them in Washington, D.C., and they hold field hearings around the corner. And it's some of the most difficult testimony to read, but Black people come and explain what is happening to them, what they have experienced as a result of Ku Klux Klan violence, mob violence, throughout Alabama, Georgia, Tennessee, throughout the South. It is harrowing and horrifying. And that, of course, is the basis for the Ku Klux Klan Acts, the enforcement acts of 1870 and 1871, and they are quite successful, and the creation of the Department of Justice, by the way, to provide a federal mechanism for being able to prosecute on behalf of Black people who are facing this kind of violence. I mention this because, once again, this is not a phenomenon that was fully in full flower in 1866 and 1867 when the 14th Amendment was being considered. This was something that really began to hone in and get very, very, really out of control in 1867, 1868. They're hearing stories back in Washington, D.C. This compels the creation of this statute. And I think it's important because we see a Congress, many of these are the same members who were the members who were in Congress when the 14th Amendment were drafted, are learning in real time through the course of these additional civil rights acts what is necessary to effectuate what they're trying to accomplish with the 14th Amendment. I mean, this is why Section 5 of the 14th Amendment giving Congress the power to enforce it is so important. They're learning in real time. And the same happened in the 20th century with the Civil Rights Act of 1964 and the Voting Rights Act and so forth. These are all places where Congress is then learning about a changed or switched or even newly developed phenomenon that purports to undercut the purpose of the 14th Amendment. But to see the same members of Congress dealing with that, churning over 5 years and trying to make adjustments to ensure the integrity of the 14th Amendment is, I think, the story of that period. That it is not that one thing happened and then another thing happened and then another thing happened. It is that there is this dynamic happening in which, in this new world that they have created, a country we've never had before, they are learning new things about what citizenship means. They are learning new things about what citizenship means. What do they know about being thrown off of rail cars or having to sit in the smoky section in the back? Or they don't know anything about that. What do they know about mob and Klan violence and what it can mean to have to live in the woods for weeks, as some Black people did because they were so afraid of the Klan coming to their homes? So they're learning in real time, and they're making the adjustments all to effectuate the intention of the 14th Amendment. And that strikes me as considerably more important. The colorblindness piece was, the concept of colorblindness was argued by the attorney Albion Tourget, who litigated Plessy versus Ferguson. That's where it comes from. And then it's picked up by Justice Harlan in his dissent to Plessy versus Ferguson. And now suddenly has become canon, but it's not in the 14th Amendment. And I don't think that the Reconstruction Amendments were meant to be colorblind at all. The 14th Amendment in Section 2, the punishment regime, where it purports to or suggests that states that do not allow Black men to vote will have their representation reduced, is using very express terms to talk about race and gender. The Civil Rights Act of 1866 talks about people, Black people having the same rights as white people. There was no concept of colorblindness during this period. There was a concept of equality, but not the idea that you didn't notice race. So it comes from the advocacy of Albion Tourget, who was a Northerner and a brilliant civil rights lawyer who came to live in North Carolina. It is picked up by Justice Harlan in his dissent. In his dissent, when Justice Harlan talks about our Constitution is colorblind, it is immediately followed by his statement that says, but there is a race of people so different than us that we would not consider them sitting equally on a rail car with white people, and that is the Chinese. So even Harlan is not colorblind. So how in the 20th century it has become canon, and it has now been enshrined as what apparently the 14th Amendment was meant to advance, I think is just not true.
Harlan also says there is no caste here.
He does.
I mean, those lines are right next to each other in his opinion. He's like, our Constitution is colorblind. There is no caste here.
But there is a race of people.
But there is, but your argument about caste, he also uses anti-caste language, and that's been forgotten.
He does. And so we're picking and choosing in Harlan's dissent what we like and what we don't like. But it's a very complicated, to your point, Pam, it's a very complicated set of things that are in Justice Harlan. If you read that opinion, and you know, as we all did in law school, we only read that section. We didn't get the whole thing, and so he's a good guy. But if you read the whole thing, is he a good guy? So
he's a mixed guy.
you know, I think he's a good guy, but he's a complicated guy, as they all were. So we can't just snatch one piece and then suggest that that now is canon, without grappling with how would we put that together with the other pieces. And I would say the same thing for the 14th Amendment and I know you're going to talk about it later, but birthright citizenship. There were members of that Congress who were very much concerned about birthright citizenship, who asked the question, shall we allow the child of the Chinese laborer to be a citizen? Will we be overrun, and excuse me for the offensive language, by the Malay and the Mongolian in California? And yet those same representatives vote for the amendment with birthright citizenship, one even saying, I accept that the children of the Chinese laborer, and at this point Chinese people cannot even become citizens of this country, is a citizen if he is born on this soil. So it's not just biracial. There's other things going on that they are very aware of and that they're engaged with and that they're talking about. And so I think that the amendment warrants a more robust and fulsome analysis of that 360.
We are at time for beginning our conversation so thoughtfully. Please thank our panelists.
Thank you, Jeff.
Great. I'm going to stay, and you're going to trade places.
I'm going to take my water.
Wonderful. Please. I feel like a game show host. Come on down. So great to see you. Welcome back, Martha.
Thank you.
Please. Great to see you, Dylan.
Good to see you, too.
Great to see you.
Hi,
Okay.
thank you.
Thank you. Well, this is indeed a continuation of our first great conversation. We have three other spectacular historians to introduce briefly. I want you to note the names of their books because I'd like you to read them. That is your homework, and these are just definitive books, which I'm so delighted to introduce you to now, if I pick the right introduction sheet. Here we go. Martha Jones is the Society of Black Alumni Presidential Professor, Professor of History, and Professor at the SNF Agora Institute at Johns Hopkins. She's the author of Vanguard, How Black Women Broke Barriers, Won the Vote, and Insisted on Equality for All, and Birthright Citizens, A History of Race and Rights in Antebellum America. And I can't wait for her next book, which we're going to help launch here at the Constitution Center soon. Dylan Penningroth is Professor of Law and Alexander F. May T. Morrison Professor of History at UC Berkeley. He's also Associate Dean of the Program in Jurisprudence, Social Policy, and Legal Studies. He's the author of Before the Movement, The Hidden History of Black Civil Rights. And Kate Mazur is John D. MacArthur Chair and Professor of History at Northwestern. She is the author and editor of many great books, including her most recent works, Until Justice Be Done, America's First Civil Rights Movement from the Revolution to Reconstruction, and Freedom Was in Sight, a graphic history of Reconstruction in the Washington, D.C. region. Let's begin with a round giving the essence of all of your marvelous books, which in different ways tell the stories of unsung heroes in a civil rights movement that began more than a century before the one in the 1960s, and that's during the antebellum era. And each of you have done so much to bring to life these unsung heroes and tell their stories and teach us how they contributed to the meaning of Reconstruction and to the 14th Amendment. Kate Mazur, you do such a great and vivid job on all of those antebellum abolitionists contesting over the meaning of privileges and immunities in the antebellum era. Maybe just pick a few great people and tell us their stories and how they cast light on the 14th Amendment.
Sure, thank you. And I just want to thank you for inviting me here, and it's wonderful to be here. And I guess I want to just start by saying how I came to that book, Until Justice Be Done. My earlier work on my doctoral dissertation and first book were on the Reconstruction era. And I later realized, as I was deep into what became Until Justice Be Done, that while I was writing the introduction to my first book, which was on Reconstruction in Washington, D.C., I wrote this line that was sort of like, I realized that Congress had not only abolished slavery in the District of Columbia in 1862, but had quickly gone on to repeal the black laws of the District of Columbia, which would have rendered, and already did render, free black people there sort of like a second class of people, a kind of without the full rights that white people were supposed to have. So Congress, again, the Republican-controlled Congress, not only abolished slavery, but then immediately repealed these black laws, which meant that it was kind of creating a condition of legal racial equality. And I wrote this line in my first book that was sort of like stating that they had repealed the black laws in DC without debate. And then I sort of thought, why did they do that? How did they think in 1862 that they were ready to not only abolish slavery but repeal the black laws? And who has written about why the Republicans came into Congress in the Civil War period already poised to do something like that, when you would think from a lot of the historical literature that the Republicans were they were indeed a kind of coalition of people, the white Republicans, who didn't all agree about everything. But you would also think that they were a party that really cared mainly about not supporting the extension of slavery into new territory. They were, according to the prevailing historiography, quite racist on the whole, didn't support racial equality, even if they supported stopping the spread of slavery. So why were they poised to just go ahead and repeal the black laws of DC? And that's not what got me onto that project, but later, and when I was deep in the project, I realized that I was sort of answering that question that had kind of appeared to me as I was finishing my first book. So that is, what kinds of views did the Republicans come into Congress with in the election of 1860 that set them on a course, because they had a majority in Congress, because of secession, because of the Civil War, to not only, in the end, abolishing slavery, but also passing these new federal policies that the previous panel was just talking about, like the 13th, 14th, and 15th Amendment, the Civil Rights Act of 1866. And so I was sort of thinking about the pre-Civil War history of what became these Republican leaders. And I was also thinking about the growing move among historians to talk about something that I think Ira Berlin called the long emancipation, thinking about how actually the end of slavery in the United States began in the period of the American Revolution, when at the time of the American Revolution, all the states of the United States had legalized slavery. And so what people sometimes call the first emancipation began in the American Revolution period, and later as what we now know as northern states began to abolish slavery in a variety of ways, creating, in a sense, this sectional division over slavery, right? So you had to create a free North before you could have a sectional division of slavery over slavery. And so historians were writing about this first emancipation in new and interesting ways, and thinking about, the ways that the North, the free states, were in reality a post-slavery society, right? So you actually have the emergence of a post-slavery North before the Civil War. And then what the Civil War does is create, is result in the end of slavery in the place where it was most entrenched, where the most people were enslaved. And so, the question that I had, it was what lessons from the post-slavery North did people learn, and did they then bring into the battle over slavery and emancipation and the kind of what flowed from that during the Civil War and Reconstruction. So it turns out, or what I found and kind of put forward, was that there was indeed this big fight and the series of disagreements over what would be the status of free African Americans in the post-slavery North, and that many of the people who were involved in those struggles that were mainly at the state level but not exclusively at the state level, the white political leaders of that of what became the Republican Party, many of them emerged out of that first civil rights movement. So in other words, they came into Congress in the 1860s with experience arguing over precisely the issues about race and law and equality that had been on the table in the pre-Civil War period. They had ideas about what the Privileges and Immunities Clause should mean, the original Article 4 Privileges and Immunities Clause should mean for African Americans, or when it comes to race and equality, because of those fights, and they brought those into the Civil War and Reconstruction. They had ideas about what was wrong with the black codes of the North and why those were unjust and needed to be abolished, because they had been fighting over those issues in the antebellum North. And so, unlike a kind of I'm not saying that the sort of story that we know of what's going on in the former Confederacy in 1865 and kind of what Sherrilyn was talking about earlier about, shirts coming back and reporting on what's going on in Congress, looking at that, all that it matters and really did inform the debates about the 14th Amendment and the Civil Rights Act, but so too did this prehistory of struggles over of the future and fate of free black people primarily in the free states. So that kind of frames out the book and suggests that the whole story is not just what happened in 1865 and 1866 and 67 and 68 and 69, but that the people, and think about it, like the people were living human beings who had experiences with these questions as they went into this really cataclysmic period. So they brought the ideas and the fights and the struggles that they had been involved in into this period. So I didn't really answer your question about the Privileges and Immunities Clause. I can talk about that too, but I just wanted to kind of give the larger picture a little bit.
No, that's great, and it's such a riveting and crucial story that it was, as you said, free black people asserting their rights in the antebellum period that gave the way to the Reconstruction amendments, and that's the subject of Dylan Penningroth's book too. We had a great panel with both of you about a year ago, and it was so fresh and surprising and memorable to hear the individual stories of the black people who made the first civil rights movement, as you both call it. And Dylan, I was just reminding myself of the intro to your book. You talk about your 27-year-old uncle who in 1976 made a tape recording of his great uncle describing his relative who was a slave in Cumberland County, Virginia, and drove a boat across the river ferrying Confederate soldiers and was paid for it. And you say that story shows that black people actually were able to enforce contract rights even when they were enslaved, and then that gives the way to this amazing book with so many vivid stories of individuals like that asserting their rights. Tell a few of those stories and why it's so central to understanding the first civil rights movement.
Thank you. And thanks to all of you for being here today. It's really a pleasure and a privilege to share some of these conversations with you. So the story that Jeffrey Rosen was just telling was of my uncle, Craig Baskerville, who interviewed his great-great-uncle, Thomas Holcomb. And Thomas Holcomb, on this recording, I have this little tape back home, he talks about his father, named Jackson Holcomb, who was an enslaved man in Southside Virginia, Cumberland County. And just as you said, the end of the Civil War, Confederate troops running through the woods, they have to get across the Appomattox River. He has a boat, so he takes them across, and when they get to the other side, the soldiers paid him. And I remember hearing this recording in graduate school. My mom gave it to me, and I thought, that's weird. Like, why, they've got all the guns, why would they pay him? And I wrote my first book that was about enslaved people's family relationships, community relationships, and property relationships, 2 years during slavery and how that carried over into freedom. And what I decided was that that was an extra legal system of property ownership and contract making that sustained a set of understandings among Southerners that made it possible for these soldiers to not be surprised at the thought of having to pay an enslaved man for bringing them across the river. But where I think I would, in the book that I just finished, Before the Movement, the one thing that I have come to understand or to believe is that it's not an extra legal system of property ownership and contract, but neither was it legal. Jackson Holcomb couldn't have enforced his contract rights. No way, he would have been laughed out of court. But what he had was privileges. And so there's this kind of interesting paradox within the slave system. Slaves had privileges that most Southerners recognized and acknowledged. They couldn't enforce them in court, but they were widely understood as having purchased within the same general system of understandings about what was property and what was a contract that white people's property and contracts participated in, right? It's just sort of the common sense of law that every adult person has. You can't go to court about it, but there are certain consequences for violating those. Now, during slavery, the consequences are quite modest, right? You can get away with this stuff. But what changes after emancipation is that now former slaves can go to court, and they begin to do so in droves. And so one of the things, the question that I started out my book to find out was, what did former slaves, what did black people in the South and in the North, what did they do with civil rights? So we've been talking a lot about civil rights and the differences between political, social, and civil rights. But I wanted to see, what did black people do with their civil rights, narrowly defined as property, contract, and standing? And so I started going around to county courthouses and asking to see the records. And they would usually let me in the back room, and I'd pull down these docket books, and I'd start copying down names. And by the time I was finished, I had 14,000 cases, civil cases, about 25, 30,000 names. My research assistants and I looked up all those names on Ancestry.com, the electronic version, not the swab version. And by the end, we discovered that of those 14,000 civil cases, 1,500 of them involved African Americans. And this is going from 1872 through 1962. And in fact, you see an enormous number of cases in places where you might not expect it, like Mississippi and Virginia. And you see a great number of these in the period that we think of as the nadir of race relations, when there's lynchings everywhere, the 1880s, 1890s, 1900s. And so what I was trying to do is figure out, what did black people do with civil rights? And what they did is they tried to enforce them in court, not necessarily against white people, usually against other black people. So the things that I took away from this project were, one, that it's so important to focus on the local as well as the national. It's important to focus on state law and local law as well as federal law, constitutional law. And it's important, lastly, to focus on private law, because that is where most people, even in those days, tended to care about. That's what they cared about. Do I have an enforceable contract? And this is, of course, the other thing that's going on is that American law schools are sort of beginning to take their modern form, and contract law is beginning to modernize in the United States. Black people are going to court in this very same period. Their cases are not just in the local courts, but some of them are percolating up to the appellate courts, and they begin to have an impact on case law of property and contract. Now, you can't see it necessarily because legal professionals at every stage of the process treated race opportunistically, which is to say that sometimes they buried race and sometimes they lifted it up. So you think about the slaughterhouse cases. I think it's Justice Miller. He states pretty unequivocally that the 13th, 14th, and 15th Amendments are all about race. It's about the freedom of the African race. But then Justice McReynolds, in a later case, contract case, he gets the transcript of record which clearly states on the very first sentence that the plaintiff is a black man trying to enforce contract damages for mental anguish, he buries race, and he refuses to talk about it. It's nowhere in the published opinion on Westlaw. And so you can see this again and again, both in constitutional cases and in private law cases. Lawyers, trial court judges, appellate court judges, and then treatise writers and law professors are constantly making decisions about when to put race into the record, when to talk about it, and when to take it out. They're not just erasing it, sometimes they put it in because they want to advance a certain legal argument. Sometimes they take it out because they want their holding to sweep more widely. That's why Justice McReynolds did that in Byers. So there's a whole bunch of things going on that have an impact that emanate up from the local to the state level and on to the national level that still are reverberating today.
It's a really powerful insight to emphasize the local, and it very much resurrects the first civil rights movement, these unsung heroes who, using the law in very strategic and practical ways, are ultimately able to transform the Constitution. Martha Jones, we just did a great panel at the American Revolution Museum last weekend where you told the history of racial equality from the founding, well, through the civil rights movement, so powerfully in 10 minutes, singling out a couple of heroes who we don't often think about, including Mum Bet, who sued for her slavery and freedom in Massachusetts, an enslaved woman known as Elizabeth Freeman. Abigail, John Jay's enslaved person who you wrote about in the New York Times. See, just for our, because I think it's so useful and also helps the National Constitution Center also put a spotlight on these heroes in the course of teaching this history. Single out a few of them and tell us how they transformed the Constitution and contributed to the Reconstruction amendments.
So thanks for that, Jeff, and thanks to the Constitution Center, thanks to the folks at the Federal Judicial Center for having us. I'll take you up on that. But I'll say first that I hope what maybe is beginning to become clear is part of what I think we all share, which is a perspective about where to look for the history of law, how to understand the history of law that extends far from the texts of high court opinions, of judicial opinions. Kate Mazur is telling us everything about the world of abolitionist activism and deliberation. Dylan is telling us about what happens in those local county courthouses. As I begin to tell my story, I think what you, I hope, begin to hear are the ways in which there are many sorts of Americans, if you will, who are engaged in the interpretation, the reinterpretation, the promulgation even of the terms of things like constitutions. So let me, if I could, come back to Elizabeth Freeman, because we were in a conversation about, of all things, the Declaration, which maybe today has become it still persists as a touchstone, still is appreciated as an aspirational text. We're about to, next year, embark on a year plus of commemoration, celebration that will include, for many Americans, a rereading of the Declaration. But it was true in the 18th century that the terms of the Declaration were far more than that. That there were Americans who believed that in the terms of the Declaration were words that could gain traction in American courts, words that did, in the case of the state of Massachusetts, become incorporated into a state constitution, and then take on lived meanings in the lives of enslaved people there. Elizabeth Freeman is enslaved in Western Massachusetts. She is then known as Mum Bet. She is enslaved in a very provocative, politically rich scene in which activists in Massachusetts are beginning to work through the terms of the Declaration, their own constitution, and these fundamental principles. What does it mean when we say that all men are born equal? Well, Freeman is an enslaved person, right, without her own literal access to courts, to judges, to constitution makers, but she's in the rooms and she's hearing these deliberations. She's hearing these principles be enunciated by the folks we often refer to as white propertied men, but she hears the resonances for herself. And when conditions in the household where she is held enslaved become extremely intolerable, she looks to those words, those ideas, finds herself a lawyer who himself has subscribed to these ideas, at least for himself and people like him, and they bring suit. And they win, which is to say that the court ultimately, now it's important, it's not the court that holds, a jury holds. And this is always important for me, right? That a jury hears her case and that of a companion case for a man named Brom, and conclude that that equality principle from the Declaration into the Constitution of Massachusetts means that slavery is not possible in the state of Massachusetts. And Freeman's case becomes one of a cluster of cases that really is the death knell of slavery in the state of Massachusetts, long before we get to the dawn of the 19th century. Here, as a last point, I want to emphasize, how do we tell this story? It's from shards of records from a local courthouse. It is from reminiscences of the family of the lawyer who had represented Freeman. It's from Freeman's will. She goes on to be a free woman, a property owner, heads a family, leaves philanthropic, modest but important philanthropic bequests. We learn from her will. This, for us, I think I can say, is are keys, essential keys to understanding the history of law, how something like the Declaration becomes not only part of a state constitution in its formal sense, but how someone like Freeman then helps us to understand what it means to breathe life into that text, to give it lived meaning. And so she is indeed one of those extraordinary figures who is memorialized over at the Museum of the American Revolution. I got to see the exhibit after we had our conversation, and it's wonderful.
Magnificent. Thank you for telling that story and inspiring us to learn more about it. After you gave that great talk last weekend, I started digging and found that her lawyer, Theodore Sedgwick, was a Federalist who'd supported the ratification of the Constitution, but then he ends up at the War of 1812 leading the Hartford Convention, which wants to secede because they don't like Madison. It's just the twists and turns are so striking, and that's why it's so exciting and important to learn about history. And we lawyers are not trained to dig deep into history, focusing instead on the text, but we're on a crusade here at the Constitution Center to teach history through storytelling and inspire people to dig in deeper, and you're a central part of that. Well, let's now take up the question of birthright citizenship. It was central to the 14th Amendment. The debates arose over debates over civil rights acts. Kate, what does the debates over the birthright citizenship clause tell us about its meaning, and where did it come from?
Well, one of the things that is noticeable about Well, all right, to back up, so I think one thing that we need to recognize is how ambiguous and sort of amorphous citizenship was at the founding of the United States. So first of all, the founders are making a transition from talking about, in the British case, being a subject of the crown to talking in the vocabulary of citizen of a republic. And as you all are probably familiar with, the term citizen is used several times in the Constitution, but it's never defined who is and who is not a citizen. One thing that interested me a lot in my book was the Privileges and Immunities Clause in Article 4, Section 2 of the Constitution, which alludes to state citizenship, which is a reminder that state citizenship, and this came up on the panel, Sherrilyn Ifill mentioned this earlier, state citizenship was really quite important, although also not really very well defined from the beginning of the United States. So I think first we have to sort of keep in mind that there was no single definition of citizenship at the beginning of the United States. Also that state citizenship was very much in play, and these questions about sort of who was a state citizen and what sort of rights and privileges did a state citizen, however it was defined, carry when they went to another state was very much in play. And then another thing is that for the most part, authorities believed that the tradition of essentially what we now call birthright citizenship from Great Britain carried forward into the United States. So there was kind of a taken for granted sensibility that if you were born in the under English common law, it had been the case that if you were born in the domain of the king, you were a subject essentially of the king, and they carried forward that idea into the United States, the idea that if you were born in the United States, you are a citizen in some form, although again, they didn't define very well what the nature of national citizenship or state citizenship. And then, however, there was this huge exception for free black people. So the presumption was in essence that a white person or a descendant of Europeans born in the United States was a citizen of something, like a state or the country. But there wasn't the same kind of consensus when it came to free African Americans. And there were actually a lot of free black people and growing numbers of free black people as gradual emancipation took shape in the North and in the slave states. There were, as Martha, I hope will talk about and has written about a lot, in the case of Baltimore and Maryland in particular. So, I want to pass the baton to my co-panelists here, but just to say that, well, I'll say one more thing, that in my work, the question of the state citizenship status of free African Americans takes a pretty big plays a pretty big role, because from roughly the 1820s and the Missouri crisis all the way up until the passage of the Civil Rights Act of 1866 and the 14th Amendment, the question of the status of free black people under the Privileges and Immunities Clause, Article 4, Section 2, is in play, right? And there's this really big ongoing debate about whether free black citizens of a state like Massachusetts or New York could carry their citizenship rights with them and had the right, for example, to travel from state to state or to settle in a state like Missouri that tried to bar the in-migration of free black people into the state. So this is like a kind of submerged debate that I tried to bring to life, that once I started to understand that this debate was actually hotly contested from the 1820s onward, I started to see it everywhere. It's in the debates over what becomes the Compromise of 1850. It is in the Dred Scott decision, even though it's not a primary part of the Dred Scott decision. And so when we get up to the point of talking about the Privileges or Immunities Clause of the 14th Amendment, which is part of the story of citizenship, we have to sort of understand the backdrop of this kind of ongoing discussion about the Privileges and Immunities Clause in the original Constitution. But to circle back to birth, so that's a question of who is understood as a citizen within the United States in this time period, and what kinds of debates are the people, the framers of the 14th Amendment and the Civil Rights Act responding to that is a subset of the large, well, it's part of the question of citizenship, but the question of why and how birthright citizenship is codified, I want to sort of pass over perhaps to Martha, who wrote a book titled Birthright Citizens.
I'd love you to answer to Martha, and Kate just introduced this distinction between the rights of citizenship, which are those that you can carry from one state to another, which is why political rights are not rights of citizenship, because you can't vote in Virginia if you're a citizen of Maryland, but contract rights and so forth are, with the question of who's a citizen, and she said that Dred Scott said black people couldn't be citizens, and the 14th Amendment is designed to overturn that. There is a debate over the meaning of citizenship in the Civil Rights Act, and one of the sponsors stands up and says that it doesn't include those who are subject to foreign powers. Does that exclusion mean just kids of diplomats and Native Americans who are not taxed, as the conventional understanding has been, or might it include kids of people who are not here legally?
Is that me?
That's you. You wrote the book.
It won't surprise you, I need to go back just a little bit, because I think there are a few things that are important to know about how we get to the 14th Amendment. And the first is that before the Civil War, free black Americans have organized themselves into an independent political movement, excluded from sitting in state legislatures, excluded from sitting in Congress. They form what we have come to call the colored convention movement, state and local and national meetings in which black Americans gather to debate the issues of the day, to strategize, to insert themselves into political culture, even as they are formally unwelcome. And one of the questions that surfaces very early in those meetings in the 1820s is the question of citizenship. So why? Why are black people preoccupied with the question of citizenship? As Kate says, it's sort of amorphous, it's sort of assumed. They are concerned because by the 18-teens, what has also solidified in the US is a political movement called colonization, led by the American Colonization Society. And the American Colonization Society is organized at its core to preserve the US as a white man's nation. What does that mean? The colonizationists anticipate slavery is ending in the North. It is likely to end, perhaps in years, perhaps in decades, perhaps after a century. It is likely to end thoroughgoingly. And when it does, colonizationists are there to remove black Americans from the US. They propose the Caribbean. They propose Mexico. They land, very importantly, on Liberia in West Africa, what is today Liberia in West Africa. And black Americans are living with the prospect, the threat, the presence of forces that are organized to remove them from the US. And they believe that citizenship, right, that citizenship might be the bulwark that will save them from arbitrary removal without offense and without cause from the United States. And they promote, ultimately, this principle of birthright. They read the Constitution and they know that the president is a natural-born citizen. And they say, why aren't we? There's no color line in the Constitution. And this principle gets worked and worked again. We see it first in 1862 when Lincoln's Attorney General, Edward Bates, is asked a question: can a free black man pilot a ship up the coastal waters of the United States? Well, he only can by federal law if he's a citizen. And Bates, in a long and very learned opinion that really summarizes decades-long debates over citizenship, says indeed, yes, he can. And this is the beginning of a pivot, right, at the federal level. We see it again in the Civil Rights Act of 1866. Birthright citizenship is there. And finally, the principle is constitutionalized. I'll try just very briefly your question. Right? So what's going on here with the 14th Amendment? Whose citizenship, for what purpose? We heard this morning very rightly, right, that in part Congress is looking to now undo the force of the Dred Scott decision. But it doesn't write the 14th Amendment by those particular, we might even say narrow terms. Congress knows that this 14th Amendment and the birthright principle will now apply to all persons born in the United States. That will include the children of immigrants, be they immigrants from the Caribbean, be they immigrants from Europe, be they immigrants from even parts of the world not wholly anticipated. But most importantly, for the rest of the 19th century, I think, for this particular amendment, it is knowingly written by those terms to include the children of Chinese immigrants born in the United States, people who by federal law will be excluded from naturalization. Their children are unequivocally citizens of the United States, and we learned that from the Supreme Court finally at the end of the century.
Superb, very helpful history, a great way to introduce it. If this were a We the People podcast, we'd have arguments on both sides of the legal question that's being considered today about whether or not the Womkin Art case should be overturned and birthright citizenship should be revised. But this is a great introduction to the deep historical debates that gave rise to the case today. Well, I want to take a round as we conclude this great panel on what historians can teach judges when it comes to contested questions of history. Maybe just focusing on what you think would be the most basic question in all of constitutional law, which we talked about in the first panel. Is Brown consistent with original understanding? And you heard disagreement even among our three panelists this morning about that question. I remember having the privilege of one great dinner with Justice Scalia, the one time I had the honor of meeting him, and I screwed up my courage late over drinks. And I said, Justice Scalia, you know, you're an originalist, but someone stood up in Congress and said, this isn't going to affect schools. How is Brown consistent with original understanding? He paused for a second, he threw back his head and he said, you know what, no theory is perfect, which was a great answer. But you heard this morning, Kate, Ilan says, don't look at the original understanding. And what people said in Congress, look at the text. And the text is colorblind. And Sherrilyn said, colorblindness isn't in the text, nor is you need a background principle. And the anti-caste principle is the right principle. And I think Pam was judicious, but not directly weighing in on that question. But given it seemed that all three of our panelists were saying there's an essential disagreement when the amendment was passed about how broadly it would sweep, what principles it was meant to instantiate. Given all that, is there a single best meaning of the text? And now the historians, including all of you, are being asked to file briefs and weigh in on contested questions of Reconstruction history. What light can you really offer to judges? Kate?
Small question.
I think you all want to talk about it. So.
I mean, I think, okay. So in my view, first of all, historians are not judges, and we also are not really responsible for or necessarily interested in coming up with a theory of constitutional interpretation. That is your job. And what I feel that I do is try to ask questions about the past and illuminate the past in ways that are not actually driven by a desire to influence court cases. And then insofar as the areas of my expertise are relevant for things that come up in court, I'm happy to provide my expertise. But I have views on, constitutional interpretation, but that's not my lane, I think. And so I want to say a few things about how I think what historians do and how we tend to think and ask questions is distinct from what judges and lawyers and sometimes law professors do. So one thing is what I just mentioned, which is we tend to ask questions that are generated by, our own questions about the past and kind of trying to clarify what happened, maybe trying to write the histories of people who historically have been written out of history or not paid attention to in history, who we think deserve to have some attention on them, an interest in going into archives and finding new sources and figuring out what they can tell us about the past, an interest in engaging in conversations with other historians that, again, are not driven by desire to solve legal problems in the present, but are out of a kind of series of questions about, things like, a quintessential one is like, why did the Civil War happen, right? Like, or what is the nature of African Americans' resistance and to racism and to sort of structures of racism. So that's one set of things. But another is that we tend to be more interested, I would say, in context than in text. We are very interested in texts, but this, by definition almost, context really matters to historians, right? So the notion that we would go in and say, well, like, here's a sentence, and I'm just going to look at the words, and I am going to parse out what those words mean to me, and I might consult a dictionary to see what those words meant at a particular moment in time. Like, that's just really not the kind of work that we do. We are interested in the meaning of words, but we would also want to ask, well, who wrote those words? What political purposes were they written for? What was the person trying to do who wrote those words? What are the surrounding words? Where was this text published? Who criticized it? Was it authoritative? Was it, did people contest it? So that's one thing, is the kind of text versus context distinction, and I think we are often very, very interested in context, and complexity is another one. So we are not driven to come down on one meaning often. We often will recognize that meanings are contested, and that the sort of texture of history is actually struggles, arguments, contestation, back and forth, people resisting, somebody saying something and somebody saying something else, and sort of the idea of fixity, and that we would be able to just sort of come down on this is the singular meaning of this text or event is not necessarily how we really roll. And there are really real reasons why courts have to do it differently, right? Or why lawyers are doing things differently. They are trying to fix meaning. They're trying to make an argument. They desire a particular outcome. And so when they invoke history, they often do things that rub us a little bit the wrong way, because that's just, we're not comfortable with that level of, we don't feel so secure. We actually come into history, one word that I really like that is, we come in with a lot of humility about the past and about the limits of our understanding, about the idea that we cannot know everything, that so much has been lost to us, that actually we are humble before this sort of complexity and expanse and the things we can know, but the things we also can't know. And so that's another way in which some of the uses of history in the legal context disagree or sort of feel not quite right to to many of us who are historians. So yeah, I think, you know, what I'm trying to say is that I'm not trying to say that never the two should meet or can meet. I actually think that these conjunctures are really, first of all, they're very important, especially as courts are turning toward originalism or history or the past. It's very important, I think, that we have these conversations, and I actually also appreciate them a lot, but I think that recognizing some of those points of friction or ways that most historians go about things and the distinction, I think is also really important.
Fascinating. Dylan, you've written an important work of legal history. What can't and what can historians teach judges?
I think Kate's absolutely right that we historians, we come to the record with a lot of humility and with a set of different purposes. There's an important distinction to be drawn between the job of a historian and the job of a lawyer or judge. I also want to just underscore what Martha said a few minutes ago about looking not just at the Constitution or federal law, not just at appellate federal courts, but at the broad panoply of courts that are scattered all over these United States, all the way down to the local level. Those are so important. I think maybe one way that I could answer your question is by sort of tweaking it a bit and asking a slightly different but related question, which might go something like this. How revolutionary was Reconstruction, and in what sense? And I think my take on it, which I think others might disagree with, I think you and I have had some conversations about this as well, is that it was revolutionary in the world of the political. It was revolutionary in the world of the social, which was talked about earlier. But in the world of the civil, it may not have been so revolutionary precisely because of this world of privileges that I talked about earlier, the participation of enslaved and free black people in the broad grid of understandings that underpinned white people's property and white people's contract relations. And so what happens in the 1860s, 70s, and 80s is that Republican judges, the same people who go in and they write the Reconstruction amendments, the other thing that they're doing is they're writing into the Constitution and into state law, state appellate courts. They're writing what the historian Bill Nelson calls the jurisprudence of anti-slavery, which is to say that they're writing into these cases and into the treatises a conception of slavery and freedom that is essentially a binary. Slavery is personal, race-based coercion, and coercion is an overseer with a whip. Unless you have an overseer with a whip, you are not being coerced. This obviously leads an incredibly wide scope for economic duress, what today, you might hear it described as business compulsion. In other words, what the judges of the 1880s and 90s are saying is that market exploitation, if you're exploiting someone through the normal operation of the market, that's perfectly okay. They're also saying that personal domination based on gender, age, or disability is also okay. What's not okay is using race to coerce people. That, and you can see in a case that's in many of the case books today, Wolf versus Marlton Corporation, using race to coerce is wrongful threat. Now, what's interesting about that case, Wolf versus Marlton, and I'll just end with this, is that the legal professionals who argue the case clearly understand that this is a case where there's a transaction where a couple, a white couple in South Jersey, just across the river from here in Philadelphia, they make a deal to buy a house, a tract house in South Jersey. Then the couple they get divorced, and now they want to back out of the deal. And so they tell their agent to go to the developer and threaten to sell the property to a person who the kind of person you will never sell another property in New Jersey again. Now, the judge in the case clearly understands that the threat is to sell it to an African American. And I actually talked to the son of one of the lawyers in the case, Arlen Spector. Shane Spector told me, oh yeah, they're talking about selling to a black person. That never shows up explicitly in the trial record, but it's strongly alluded to. The judge knows what's going on, and he alludes to it. But then when it goes into the case books, it somehow gets transformed into, from selling to a person of color, a black person, it gets transformed, this idea, into the threat is that they're going to sell the property to an owner who will convert it to an industrial use, which is a very different thing. And now it's in the second restatement of contracts as a threat to, if you read the note and comment on that, it's in the second restatement as a threat to sell to an industrial seller. But in fact, it was a threat to sell to an African American. So I guess the big takeaway that I would say is that when you're thinking about what lawyers and judges are doing, and they say that they're being colorblind, you should be very sort of aware of the larger context, this long history of legal professionals and litigants deploying race, not necessarily to get at black people, but to advance the legal doctrine or to win the case. They're deploying it for their own purposes. So that's sort of the kind of thing, the kind of context that I think that I can bring to this conversation.
Fascinating. Martha, the last word in this great discussion is to you, and for that reason, I'm going to ask you to answer both questions, both what can judges teach historians and how revolutionary was Reconstruction?
When I went to law school, I learned a story about birthright citizenship, and it went, Dred Scott to the 14th Amendment, done. Maybe some of you learned that story too. And as a historian, I was able to teach myself a different story. And I'll tell it, but I'll tell it with the preface that I think that part of what, at least I'm driving at this morning, is that history not only insists that the historian be humble, but I think it suggests to the judge a kind of humility as well. So, we all know what Dred Scott was. But in my work, for example, I'm able to enter into the daily life and the intimate life, the family life of a justice like Roger Taney, and learn how involved, how intertwined Taney's life was with free African Americans, to help us appreciate that Taney understands fully the implications of his conclusion, black people cannot be citizens of the United States, in the lives of people who are not only abstractions, but his intimates. I'm able to remind you that there are two powerful dissents in Dred Scott. Dissents that not only reach back to decades of debate about citizenship in the United States, but that anticipate arguments that will gain traction and with the 14th Amendment become, indeed, as we say, the law of the land. I'm able to tell you that in those days, federal judges rode the circuit, and that members of the Supreme Court take their dissents out into the world and rule by way of them, despite Justice Taney's opinion in Dred Scott. I'm able to tell you that in my home state, the great state of Maryland, when in 1858, the state high court is asked to adopt the rationale of Dred Scott into its own jurisprudence, the court says, no, thank you. We are a state with 90,000 free black people. If we put them outside the law, we are inviting mayhem. And so our civil rights extend to black Americans in this state, even if they may not be citizens, even if they may not vote, contract, sue, the protection of one's person and property will be the law in the state of Maryland. I'm able to tell you, right, that in 1862, long before we get to the 14th Amendment, Edward Bates is already rewriting Dred Scott and in essence overturning it for all practical matters. I'm able to tell you that as much as the judiciary comes to mark Dred Scott as an exception, as an error, as a regrettable moment in many senses, including the long career of Justice Taney, men like Frederick Douglass are not going to let you forget Dred Scott. And part of why we remember Dred Scott today is that Douglass, in speech after speech after speech, reminds the nation how low it can go. It warns the nation against returning to the literal letter of Dred Scott, but to the spirit of Dred Scott. And when we remember the case today, we have Douglass, in a sense, to thank for that, not the judiciary. So as a historian, I can tell you those things. How that lands for you, I cannot say. But it is to strongly suggest, right, that there are many, many characters, there are many realms in which the Constitution, judicial opinions are being interpreted and thought and rethought and remade in real practice. And this might engender in you all, I imagine, frustration. Justice Taney was bereft at how Dred Scott was ignored. Some of you may know he pens a supplemental opinion, 50 manuscript pages. He's waiting for the opportunity for the next Dred Scott case to come before his court so that he can reiterate and double down on his arguments, because he has failed to persuade on the ground about that which appears so sure on the page. And for me, that is the power of history, to give us that kind of, I think, humbling perspective on the work we do, and a reminder that my work, like your work, will be judged by time and by next generations, and not only by the expediency of our own moment.
Beautifully put. What a powerful image. The limited capacity of the Chief Justice of the United States to influence history, hand printing copies of his own opinions in order to, in the wan hope that people will listen. And ultimately, though, you say, history is the judge. For casting so much light on history, please join us in thanking our panelists.
Wow.